Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, your go-to YouTube channel for insightful discussions on legal matters that affect everyday life. I'm Melanie van Orde, a licensed paralegal that's passionate about unraveling the complexities of law and providing clarity on legal issues. In today's episode, we are diving into a topic that can impact anyone navigating the legal system, the dynamics of a lawyer-client relationship, especially when it encounters challenges or breaks down. Joining me today is Phil Stiles, a seasoned legal counsel with extensive experience in handling client relationships throughout various legal scenarios. So together we'll explore the factors that can lead to the breakdown of trust between lawyers and their clients and how these situations can be navigated. Stay tuned as we delve into this important discussion. Phil, what are some of the common reasons why a solicitor-client relationship breaks down?
The most common theme in solicitor-client breakdowns or the relationship breakdown usually has to do with a loss of confidence or trust on one end or both ends, and often has to do with someone feeling that they are not being communicated with nearly to the extent that they should be, whether it's a lawyer trying to get a hold of a client to get instructions, or whether it's a client simply wanting to get an update from their lawyer and they feel like they're out of the loop, or whether it's a loss of trust based on a fee expectation from the lawyer or a fee expectation from the client that's not consistent with what their expectations were. Bird's eye view of the solicitor-client relationship, usually the breakdown has to do with a loss of trust or confidence on one end or both.
And then can you provide an example of where a breakdown in the client-solicitor relationship occurred and how it can be resolved or managed?
So a hypothetical scenario would be where a lawyer was hired and there was an expectation from the accused who hired the lawyer that they would be able to do certain things for them, and someone may have been falsely under the impression that the lawyer had guaranteed a certain result or guaranteed something. That individual, let's say a Crown pretrial conference happened, and the lawyer relayed the results of what the Crown was seeking for resolution of their case, and it was completely inconsistent with what the lawyer had originally said would likely happen or would happen in their case. Can't think of a scenario where a lawyer should be saying something will definitely happen, because there's never any certainty. But let's say the client feels as though he's been let down or misled. Then the client may feel that he no longer trusts the lawyer. And as soon as the lawyer learns that the client is no longer trusting them, or that their advice isn't trusted, guidance isn't trusted, then there's been a breakdown in the solicitor-client relationship. Sometimes a solicitor-client relationship breakdown is as simple as one party is not doing something that's consistent with the retainer agreement between counsel. Comes up often in the context of fees. The fees are set out in the retainer agreement, and there would be a payment schedule that usually is particularized. And if the client is not following that and isn't being very communicative about it, then that also constitutes a breakdown in the solicitor-client relationship. It's a wide spectrum, but again, it usually has to do with a loss of trust and confidence regarding some issue.
How are these issues usually resolved or managed?
I would say at least 90% of solicitor-client relationship struggles are resolved without without the lawyer needing to be removed from the record or applying to go off the record. So what that means is when you're hiring a lawyer, they go on the record for you in court and officially state that they are representing you in court. And if a lawyer is to go off the record, that means that they're officially telling the court, and the court is granting an exit essentially from the relationship. The court's officially saying, okay, this lawyer no longer represents this individual. Most times, the solicitor-client relationship strain, shall I say, is usually rectified with a frank conversation, a renewed commitment to meet expectations, whether it's the expectations that the lawyer has or that the client has. If they are not resolved, the ultimate remedy is to be removed from the record or for the client to remove the lawyer from the record. Beyond that, there's avenues to complain to the Law Society. The loss of trust may give rise to a legal issue in somebody's case. For example, a ruling that there was ineffective assistance of counsel is also an appeal route too. So there's remedies after the fact, but usually the relationship ends by way of what we call an off the record application.
And then, Phil, what advice would you give to clients who feel dissatisfied with their lawyer but are unsure how to address it?
Well, I think it goes both ways in that the best or the first kick at the can should always be a direct conversation. Nobody should ever feel embarrassed or shy to bring an issue directly to their lawyer and say, look, this is what I feel the problem is. It saves a lot of time on the lawyer's part. It saves a lot of headache and guesswork from counsel's perspective. It gives you the chance to have your grievance or your issue essentially nipped in the bud. The worst thing that can happen is if you're not communicative about your problem, the problem won't get rectified. It'll be off your lawyer's radar. Then it will be you get to something serious in court where you really need your lawyer and you need that strong relationship, and you'll go in with feeling of distrust, which couldn't be worse because likely not going to rely on what your lawyer's saying, and you'll be speculative. The relationship needs to be strongest when you most need your lawyer. That can all be ensured by direct communication with your lawyer at an early stage.
Thank you so much, Phil, for all the information today. And thank you to everyone else for joining us today on the Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.
But it's important because a victim can be stuck between a rock and a hard place after they do make a complaint, and they change their mind. So getting some independent legal advice for the victim is always important.
Thank you so much, Paul, for all that informative information. And thank you to everyone else for joining us today on the Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care.